wherever you are, you need to talk to the community. You need to it's an Aboriginal issue, so you need to talk to Aboriginals about it. And I think you need to go to the community, talk to the elders. First of all, you'd have to ask around locally who the elders are, talk to them, tell them who you are, what it's about. I think you would be wrong if you were to send out letters or such asking the elders to come to a meeting. It wouldn't work that way. I think you've got to go to talk to them people. I think some of the offenders think that sometimes we're too hard on them, and I think that could be right sometimes too, because some of the elders are inclined to come down very quickly, very quickly, and not listening to what they are. I think what they think is that these young blokes are bringing shame on us and they need to be brought in line straight away. They've lost all respect and we've got to really get stuck into them. And I don't think that's right. I think we have to listen to them, as I said earlier, and we have to put the shame on the action, not on the person. And I think that's important. I think these young blokes have a bigger load to carry anyhow without getting a shame factor from the elders. Personally, I think what they done is the matter that's in court.
Respect is a key word in our community. When we were growing up, it was total respect. Respect for your elders, respect for your neighbour, respect for other people's property. In our circle, I said this before, that it's an unspoken respect we have with each other. You know, we respect each other's opinion, each other's turn to to speak about different issues. So we wait. We don't have cue cards. We just sit there and we know exactly when, where, and how to come in when we're speaking. And we watch each other, you know, and we support each other in that way, because we know exactly what we're doing. And these are the people that, because we're elders in the community, the knowledge and the wisdom that we have, you know, and we've learned through our life growing up, our life experiences, both in good times and bad times, we're able to show each other that respect in that circle, as well as showing those little children what it's like. Well, I call them children anyway because they're younger than us, but showing them, and also showing the magistrate and the prosecutor exactly what it's like, what it was like in our community, that unwritten respect, okay? It's just passed down. You're taught that respect. Circle sentencing it's a learning curve, okay? And it's a two-way street. Not only the elders are they learning about what it's like in the judicial system, because we've always been running from the law, okay, hiding from the law. We've never been able to sit down and understand it and how it works in the white man's way, but also vice versa. Now, the magistrates and the prosecutors, they have no idea how it worked in our law, how we dealt with things. I mean, and we're just showing them how simple and how easy it is, because it's not an effort to us because we've grown up with that. But there's one big no-no: money. Do not bring money into it. We do it for free, we do it because we care, and we do it because we believe we can make a difference in those little babies' lives without them being sent to jail. And when you bring money into it, I mean, it's a whole new ball game, because you've got every Tom, Dick and Harry wanting to sit on the circle just for the fees. Not because they care about the families or they want to make a difference, just because of the money. So we said no straight out from the beginning. Money was never an issue. Not once did we. And every time people spoke to us about money, well, we nearly had them. When we went to other towns, we said, "You got to be kidding." Not in our lifetime will we ever be doing that for money. No way. Not to circle.
Now for some practical advice for those who have been asked to set up circle sentencing. circle sentencing demands time, and it will increase the court's already heavy workload. It's not to be held at the courthouse unless the offender is in custody. Respected Aboriginal elders will require prior tuition and post-review. Only a magistrate sitting at a designated court can consider an application for circle sentencing. Life gets too complicated if the crime is committed in another court area. The offender must demonstrate a kinship or tie with the local community. For elders, previous criminal record is not a bar to participation, but common sense must prevail. A magistrate may veto an elder's nomination. One of the reasons that it works so well is that a lot of elders have prior similar life experiences. The number of participants in each circle should be kept to a minimum. Too many voices will frustrate the proceedings and lead to unruly discussions. From an experience, it's difficult to maintain focus, especially for the elders, if too many people participate. Equality before the law is a recognition of cultural differences. However, as a result of this, circle sentencing courts struggle when the purposes of sentencing jostle one another. Chief Justice Jordan said, "With respect to sentencing, the only golden rule is there is no golden rule." This applies to circle sentencing. Rehabilitation may play an important role, but the considerations relating to punishment must not be underplayed. The composition of circle should, as far as practicable, be gender balanced. The Indigenous community now accepts this as part of their own cultural leadership model. All deliberations, including the sentence discussions, must occur in the presence of all circle participants. The accused needs to know how and why a sentence was structured in a particular way. By having the offender participate in the deliberations, the circle is giving all participants, and importantly the victim and the offender, the right to know how and why a resolution is reached, and by that, giving them the right to have their say in the whole process. This is an important issue of natural justice. It's important to remember that victims are not compelled to attend. On occasions, it is practical for the magistrate to talk directly to the victim, to highlight the benefits that might come from both the offender and the victim by the victim attending. For example, elsewhere on this DVD, you will remember the victim Tracy. I spoke with Tracy. She had concerns regarding the process being fair. I persuaded her that the greatest possibility for success in changing the offender's conduct was for him to hear loud and clear how she felt about his offending. There would inevitably be interaction between them for years to come due to them having 2 children. And now, finally, nuts and bolts. Application to participate may be made by the prosecution, the defence, or upon the court's own motion. The magistrate prepares a summary of the facts and sentencing considerations. Experience has shown that deliberations detour if great care is not taken when preparing the summary. It's best to regard the summarised facts as a skeleton upon which the circle can build relevant facts. The facts should not be summarised in a way that opens the door to dispute. The magistrate also prepares a summary of the offender's criminal history. The elders require a breakdown of the criminal history, such as 69 convictions, 40 for violence, 15 for dishonesty, 10 for drugs, 4 for antisocial behaviour. The circle then needs details of sentences imposed over the last 10 years. The offender's legal representative will produce to the circle any reports of previous rehabilitation or treatment completed. It's necessary for the magistrate to network with services such as probation and parole. An offender may not, in the usual course, be assessed as suitable for alternatives to jail because, for example, of previous poor performance. Circle sentencing anticipates that the guidelines be relaxed. The magistrate is therefore needed to talk to the probation and parole service about this. It's permissible for circle sentencing to grant a Section 11 Griffiths remand where appropriate, but it should be remembered that there is a legislative bar to reconvening a circle once a sentence has been passed. Usually, a week after circle sentencing, The elders are provided with a debriefing session. The magistrate and project officer attend the session and hurdles are discussed. Suggestions invited on ways to streamline the process without impairing the depth of probing. Often it will be the same elders who participate in the majority of circle sentencing. The magistrate and project officer should be alert to burnout. It's a very draining process, and some elders can become frail after a few sittings. To encourage open and honest dialogue, sittings of circle sentencing are not sound recorded. You would not get an elder disclosing personal information if they were being recorded, and yet an open and frank discourse is essential in the process of getting to the core of the offending. This reason reinforces the need for all discussions to be in the presence of all participants. We have to ensure that everyone in the circle feels to be on an equal footing. For this reason, care should be taken to ensure that differences in dress code do not become a factor. A practical way through this would be to encourage all parties to dress in a neat and casual way. It's important to let the elders take control. This is done in a particular way. I like to describe it as holding the reins and the elders holding the whip. They dictate how fast or slow it goes, but I can always steer it or pull it up. This is a collaborative partnership. The sentence of the Circle Sentencing Court must contain goals that are realistic and also appropriate, and that are not more punitive than those that may have been imposed by the court when dealing with the offender in the usual way. The prosecutor and the legal representative are consulted in this process. Any sentence recommended by the Circle is formalised on a sentence date not more than 6 weeks later. The sentence has no effect unless agreed to by the offender, which is done at the end of Circle and then again when sentence is imposed in open court. If the offender does not accept the sentence, the magistrate proceeds to sentence in the usual way. The magistrate and project officer take notes of the salient points of discussion. Those notes are reduced later to type and filed in the registry. The project officer then supervises the implementation, monitoring and completion of the sentence and gives Circle participants notice as to satisfactory completion. If the project officer suspects an offender may have failed to comply with any portion of a sentence, written notice is then given to the magistrate, who deals with the breach in the usual way. Remember, preparation and knowledge leads to politeness and control. Thank you.